Sonya Madison.
And I'm Jonathan Mason.
And welcome to Law Unfiltered, where we talk about various current events and some of the legal issues underlying them. So tell me.
Sonya.
Yes.
This should be perfect for you today with your background.
It's always perfect, but go ahead.
So there's something very interesting going on in the news with sexual harassment involving Fox and their CEO, I guess former CEO, or I'm not sure if he's former or current at this stage.
Former president, yeah.
Former president, okay. And just give us a little background on the situation there with the sexual harassment claims.
Well, this isn't the first time. I mean, we have the latest lawsuit from Andrea Tantaros, who's suing not only Fox News, but also Roger Ailes, who's the former president, some of the PR people, as well as HR. But according to her, as well as according to the news, I mean, you asked Megyn Kelly, she's also corroborated that they have a history of harassing women, particularly the female journalists on the show. And they're essentially saying that Roger Ailes would make unwelcome sexual advances towards them, as well as put them in an environment where they're constantly being ridiculed or constantly being humiliated or criticized based on how they look. And so that's kind of the latest one. And right now, Ms. Tantaros has filed a civil lawsuit, and she's essentially claiming I've suffered almost $49 million in damages because not only are you putting me in this type of unwelcome environment, but you're also taking away opportunities that I usually would have. She was removed from being on air. She was also removed from being the host, and she's claiming that she doesn't get the opportunity to promote herself as much as she used to prior to the complaint.
Does commenting on someone's appearance negatively, does that constitute harassment?
Well, it depends on what the comment is. But now one comment is not going to reach that level, particularly if that comment doesn't result in any type of adverse action. So if he did say, hey, come give me a hug, she said no, and that was the end of it, then that's not going to rise to the level. But now if he said, hey, give me a hug, and she says no, and the next thing you know, she's being removed from the air, then yeah, that's going to be a questionable whether or not that meets the standard. Now, what Fox News is saying that no, we removed her from on-air appearances because she went and wrote a book that violates the contract or the employment agreement that they have with her. So now she's going to have to come back and show that no, that was actually pretext or that was actually false, and they're just using that reason to compensate or to deflect from the fact that they are in fact harassing me.
What was the timing of her book versus this lawsuit and the allegations?
Well, she doesn't particularly specify, and it's an unpublished book, so
okay.
It's hard to know when she started writing it or when they became aware of it. And I'm sure Fox will try to make that argument that they became aware of it prior to April, because that's when she said she was being removed from air. But they also have to fight some of the other allegations, because she's also saying, well, even in 2015, you took me off a popular popular host channel or host programming and put me on a less popular one that not a lot of people watch. And so it's decreasing, at least according to her standards, her media exposure.
So how did she get over an argument that, well, it was based on your performance as opposed to, anything else?
Well, I mean, it's not necessarily easy, but it's not also difficult in the sense that if she can, again, show the constant repeated patterns of inappropriate conduct, she's also going to bring in, at least according to her lawsuit, at least 20 of the women that are also going to say, yes, there was this environment that was extremely hostile because we were women. That's going to help her argument. She may also be able to bring in other employees that have written books that may or may not have violated the policy, and they weren't equally reprimanded. That can also support her argument, as well as probably more egregious acts by other people that didn't get nearly the type of adverse action that she received, to show that, listen, clearly this was not an issue for them, and they're just using this to deflect from another issue.
When these type of things happen, whether it's the comments or wardrobe changes in front of people, do you have to make it known at the time that you object to, that you don't appreciate those comments, or you prefer not to dress in front of the whole staff? Or, does that kind of hurt your argument if you don't say anything?
It depends on the comment. Now, if they're asking you to undress in front of group of people and they're not asking men to do the same thing, then it's not necessarily a matter of whether it was unwelcome or not. It's clearly discriminatory. You're asking one group to do something and you're not asking another group to do something. Also, she can show that, listen, I was afraid. I couldn't say I didn't want to because I knew, based on other women who have stepped up and said no, that if I did the same thing, I was going to be equally reprimanded. So, I mean, it depends. Now, again, if, say, she just said, he asked me to give a hug, and then that was the end of it. Now, she may have to show a little bit more of the unwelcomeness of that, because I can imagine a lot of workplaces, particularly in the South, but I'm sure other places as well, where that type of behavior it's more welcomed to be able to embrace and a hug and then continue, to go on. And when you're talking about a jury of people that is going to evaluate whether or not the conduct was hostile or was unwelcomed, they're going to look at social norms.
This is a bit of an aside, but I think when you ask for a hug, it's creepy. And if you just naturally greet someone with a hug,
is one thing.
That's one thing. Or, they get some good news and you celebrate and you hug or something. But I don't know, something creepy about when you ask someone for a hug. But at the same time, in other instances, was Roger Ailes, was he present like all the time when she was changing clothes in front of people or not? Does that really matter? Or is she alleging that there were other superiors who asked her to do that?
Now, she also does have other defendants aside from Roger Ailes. So like I said, she put the PR person, she put the HR person, and she's essentially claiming, hey, I complained to HR multiple times, they didn't do anything. And so they were conducive to this type of environment, or at least condoned it. And also, with the PR, because I didn't submit to whatever advances were, they didn't promote me, or they pretty much condoned it again by submitting some kind of adverse action against her. But typically, when you are talking about whether it's one person presence, that's something Fox News can bring out. I mean, if she's going to say this was a constant environment of hostile and pervasive and unwelcome treatment, then she's got to show a constant environment, and Fox News can come back and say, hey, the president was only there once or twice during your entire employment. You've only complained about it once during your entire employment, and it became a non-issue after that because he was no longer there. So that's another issue that will have to be ironed out during the whole proceedings. Okay.
Now, is this state law or federal law issue, or both?
Both. I mean, most states do have employment laws, and most of them also do have anti-discrimination employment laws. This one was filed in New York. New York is very employee-friendly, and they also take a stronger stance on sexual harassment claims than the federal do. So, for example, with federal law, the employer can show a little bit more of a defense, whereas in terms of the strict liability, in terms of like if your supervisor did it and you complained, and the company made it clear that that supervisor wasn't acting in that capacity, that could be a defense under the federal standard. But under the state, at least in New York, if your supervisor complained, that can be a strict liability issue. You're the agent, you're the company, and considering here that's the president, that's going to be a big thing. So for her, she filed both federal and state law, and both of them, she can get damages under both statutes.
Okay. Now, how does it? Are the other actions in New York as well?
What do you mean, other actions?
Weren't there other women who filed?
Oh, yeah, yes. I'm not sure if they all filed in New York, because you can also choose based on where you're actually residing. I'm not sure if all the anchors reside in New York, as well as perform their services in New York. When you're talking about media like Fox News, they may have offices and stations across the country.
Right. Yeah, I guess I was wondering if there would be likely to be any sort of consolidation of these
like a class
actions.
I doubt it.
Consolidated trial or something.
I doubt it. We particularly when we talk about discrimination, it really is on the person. Did they discriminate against me? And while you can bring in other people to show, listen, there is this pattern and practice of conduct to bolster your argument, at the end of the day, you have to account for your own damages. You have to account for your own, adverse action, and be able to show that it was against me based on, your sex, your race, whatever it is.
Okay. So what do you think is going to be the end result of this?
I think similar to when Roger Ailes resigned after all this became an issue, I think this is going to settle. She's a current employee, and so you have a lot more anchor when you still work with the company, because one, they are very scared to terminate your employment because that's just going to add more to your claim. I mean, you're protected to file a lawsuit against your employer based on a right that you have and still be able to keep your employment. So that's one thing that Fox News, I mean, they probably don't want to continue to have her on their payroll, but yet they terminated her. That's another added claim. But also, when you're talking about a media news conglomerate, you don't want the news to be you. You know, you want to still be able to say, we objectively report the news, and whether people believe that about Fox or not, it's another issue. But you're now a big print on the news, and you are not able to talk about it. And if you do talk about it, it's kind of like in the criminal world, what you say will and can be used against you. And so I do think they're going to settle it. And I do think they want to at least try to some way compensate or some way deflect from now what their image is. Because it was one thing to have an image of being a pro-right, news station. It's another to have an image of pretty much being an anti-female news outlet.
One thing that struck me, and I have no idea how much she earns per year, but $49 million sound like a lot of money. And so I'm wondering, like, is that number like some is there some significance to it statutorily, or is it just a number they made up? Because it seemed like it could backfire by making her seem greedy. I mean, no offense to her, but it seems, but it could be that she has a contract where she's making X millions of dollars a year until, those are actual damages. I'm not sure, but I don't know what kind of light you can shed on that.
Right, they did say that 26 or somewhere around that number is punitive, and so in her mind, she's like, they should be punished for this, and so this is the amount I feel like is worthy of punishment. And then the rest, I'm sure she's obviously trying to put in, this is what I would have earned if they continue to promote me as much, and as well as, whatever's under contract. Now, she's still getting paid, so she can't necessarily argue that she's losing wages. But at the same time, is she feeling like, I would have had better endorsements, or I would have been better able to negotiate more money if you would have put me out there more so I could showcase my talent. I'm sure she's using that. I'm sure she's also trying to argue there was emotional damages. I've had to seek some kind of treatment, or I've had to take away or not be participating in other activities because I was so scarred. I'm sure she's going to bring all that in, but that is something she's got to prove. I mean, you can't just say it and then feel like a jury should be like, well, as long as you said it, we believe you. You are going to have to show, some type of quantifiable proof. Yeah,
I'm not familiar with pleading a specific amount for punitive damages, so it's kind of interesting. I always thought that number was left to the jury. I don't know. So at least you cleared that up in terms of how she got to her $49 million. But in any event, I agree. I'm not an expert on the area of law like you are, but I can't imagine that Fox would want this to go to trial.
Yeah.
Because one thing we've learned through various cases, like, for example, Bill Clinton, it's like when you get into discovery and depositions, all sorts of things come out that if you just resolved the case, it would have just never have gone public.
Well, in this situation, you already have a woman coming out. So, I mean, you pretty much helping the plaintiff establish your case. Whichever female has come out and quoted her lawsuit, it's already up to 20. That's more witnesses that are going to take the stand. That's more people that are going to be able to come out and say whatever their experience is, as well as to collaborate with each other and be able to make sure, hey, did you experience this? So we want to be at least similar and alike in our situation so that we can show, listen, yeah, he asked for hugs, he asked for us, me too. Yeah, they were making me change in front of personnel, they were doing that to me too. So it's the plaintiff or at least employer can come back and argue, that she's making this up. If everyone's saying the same thing, then a jury is going to more likely believe the 20 versus the 1. And so again, it doesn't help you to prolong this. And as you know, when you file a lawsuit, discovery 3-6 months. And this one, they just at the beginning stages, so they haven't hit discovery. But with the more that's coming out, the more they know, okay, this is going to be more people to add to our discovery list and more information we could obtain.
Would a company like Fox, it's a huge company, but would they generally have insurance to cover?
I'd imagine. But even then, insurance, I mean, and that's also interesting. Insurance companies typically pick their own attorneys, for one. And for two, they're very into settle this. They're not ones to try to really go to the trial process. So that's another reason they'll likely settle. But even if it goes through to the trial, they're only going to pay so many amount of damages. And so I don't know what, option Fox has. Maybe it's up to 10 million or so. But I'd imagine 49, 50, that might not be how much the insurance has agreed to pay in the event this happens. So Fox will still come out of some money.
Okay. So just to wrap it up, I mean, like, when should someone do something if they feel sexually harassed or any other kind of discrimination on the workplace? What's the standard? I mean, like, is it just strictly on how that person takes it and how it makes them feel? Just go over that a little bit.
Yeah, I mean, if you feel as if you're being sexually harassed, then you need to talk to your HR, you need to talk to your supervisor immediately. And even if it doesn't rise to that level, to some degree, you're still protected from the fact that that's how you felt. You filed that complaint, and if an employer comes back and demotes you for whatever reason, you're still arguing, hey, I felt sexually harassed. I was in my right to file this complaint. And even if they didn't substantiate it, that didn't give them a right to punish me filing what I felt was a good faith complaint of harassment. But now, of course, I challenge you to make sure it's a good faith complaint. Again, if someone is asking or showing, hey, come hug me, or whatever the reason is, then don't essentially conclude that one instance as harassment. Now, if it's a pattern, if it's constantly, can I take you out on a date, or will you kiss me? Some of those things that is clear is completely unacceptable in the workplace. And yes, go report it then. And that way, if something happens, you're protected, because it's all about making sure you are limited in your damage in terms of any type of employment action that can be taken against you.
What if it's a small company, just say a law firm, and there's only 2 or 3 people working there, and there's no HR and that sort of thing? Like, what should someone do?
Talk to your supervisor, because again, even though small companies like that
if the supervisor is the
person that's doing it, well, if there's no one over that person, because if you can't talk to your supervisor, talk to someone who's over your supervisor. But if you feel like, look, it's only 2 people here, me and my supervisor, then yeah, you're in a tough spot. You can always go straight to the Equal Employment Opportunity Commission and file your charge. But it should be noted that the EEOC only going to take case for 50 or more. So that's the only type of law it applies to.
Okay.
So they may not even take the case if you're just employment environment. States, different. Okay. I mean, some of them, like, if it's 1, we'll take it. Some of them, like, no, it's 20 or more.
Okay. Very interesting stuff.
Yeah, it is. Very complicated. You definitely want to seek counsel when you need to.
All right. Thank you, Sonya.
Thank you.
And thank you for watching. We'll see you next time on Law Unfiltered.